Hey everybody, I'm back! Yes, according to the interwebs, it has been 8 months since I last posted a video. I am Matt Johnston, Matt the Lawyer, and today we're going to be talking about the Federal Trade Commission's New Year's gift to everybody, and that is a proposed rule that they have that would outright ban non-compete agreements. Not only would the ban be prospective, meaning anything that going forward, but it also bans current and non-compete agreements that are still in place. So let's say an employee has left you for a little while and they still have a year left on the non-compete, you would have to rescind that non-compete for that former employer. So we're going to talk a little bit more about that. But before I get started and get in depth to what we're talking about with the new proposed rule, do me a favor, click on the bell down there and subscribe so you can get further updates. I'm going to be doing these videos once again with some regularity, and so hopefully you will learn a little bit about this subject matter, and we're going to be talking about some other subject matters as we go forward. Okie doke. So last week, at the end of the week, the Federal Trade Commission issued a proposed rule. And the proposed rule would, as I said before, completely ban all non-compete agreements for all workers in the United States. Now, the ban would be both, you can't enter into new agreements, so you're hiring employees, you're hiring other workers, you can't put those people on a non-compete agreement. If you have current workers on non-compete agreements, you have to rescind the non-compete out of their employment contract, or if the non-compete is a standalone contract, you have to rescind that contract. And you also have to provide notice to former employees who are still within their non-compete period. So for example, you had an employee who left the company, they have a 1-year non-compete agreement with you. You would have to notify that employee that the non-compete is no longer in place. Now, an important thing to note about this particular proposed rule, it does not do anything related to non-solicit agreements or non-solicitation agreements. Doesn't do anything to prohibit non-disclosure agreements. And some other things. We're going to talk about a slight sort of exception to that when I talk about de facto non-competes in a few minutes. So I want to give you sort of a quick background on how I look at non-compete agreements. I don't like them. As a general rule, they're difficult to enforce, they're costly to enforce, and enforcement may not actually get you anywhere. But they also tend to be overused in some certain circumstances. I typically look at non-competes for people who have the ability to easily set up a competing business or have the skills, the knowledge, the background, the experience to do something that would compete with your business. So most of the clients that I have that have non-compete agreements tend to be medical clinics that have a non-compete rule for their medical providers, their healthcare providers, so doctors, nurse practitioners. The reason being is their skills are easily transferable. They've already gotten their license, they have the knowledge, and if they're within a particular community, they're developing relationships with patients. And I don't want a doctor to leave a practice and go set up something on the other side of the street. So I typically look at a longer term, maybe a 2-year non-compete, but a fairly defined geographic area, usually 5 to 10 miles from the clinic. But outside of those sorts of things, or very senior executives, I'm not a big fan of non-compete agreements. Now, I know that they are useful. I know that they are standard practice in many industries, but this is one area of the law where I think you can achieve the goal that you're looking to achieve through a less heavy-handed approach. So Here's an important part when we get back to the Federal Trade Commission's rule. The proposed regulation, the actual regulatory language is maybe 500 words. It's not super long. But the Federal Trade Commission had a massive explanation about why they felt this was necessary. The Federal Trade Commission noted that in the absence of non-compete agreements, wages are typically higher. In the absence of non-compete agreements, you may get a little bit more business innovation. And they point to California. California has long had a ban on non-compete agreements, and they have a pretty thriving, innovative area, particularly around Silicon Valley, obviously, and other places where there's a lot of innovation in business. And the Federal Trade Commission feels that it's an unfair trade practice, which is why they can regulate it, to limit somebody's ability to enter into the labor market. So if you are an employee with a non-compete agreement, you are limited in what you can do post your current employment. And the Federal Trade Commission feels that that is an unfair trade mechanism, and they spend about 200 pages talking about all the various reasons why they think it's unfair. It's pretty well researched, pretty well sourced, and I think that at the end of the day, we're going to end up with some version of this particular rule. Come to that in just a second. So there's a couple of important things that I want everybody to understand. The first is that this bans everything and you have to rescind current one. So I've already spoken about that. The other part is this applies to all workers. And workers has a very different definition than employees. So an employee is obviously somebody that you have hired, they work for your business, you pay them a salary or wage or what have you. Workers encompasses other people. It can encompass independent contractors. It can encompass interns, temporary workers, workers that you hire from a temp agency to do something, short term for you. And it applies to all employees, including the most senior executives. And it includes, obviously, all sort of wage-based workers. The reason for this particular very inclusive definition, I think, is to highlight that some non-compete practices are pretty unfair. They talk about a couple of cases within their discussion, one being the Jimmy John's case. I've spoken about Jimmy John's cases in the past, but Jimmy John's once had for those of you who don't know Jimmy John's sandwich shop, they had an agreement that required every employee, including the 18-year-old kid who was still in high school and making sandwiches for a little bit of spending money, all employees had to sign a non-compete, which basically forbid them from working at any establishment where at least 10% of the establishment's income came from sandwiches. So that would ban almost every deli. It would ban other, subway type places, mom and pop delis. It would also apply to gas stations where you can go and get a submarine sandwich, like Wawa. For those of you who don't know Wawa, sorry, you should know Wawa. Anyhow, the Jimmy John's workers couldn't work there. And that was one of the sort of extreme cases that I think the FTC really picked on. The problem that I have with the regulation is that the exceptions to the rule are very, very narrow and really also promote some very difficult subject matter. So as I said, it applies to all workers, from your CEO to the guy you just hired in the mailroom to the interns that you bring on board in the summer. It applies to all workers. There are a couple of exceptions. The first exception is narrowly tailored to the relationship between a franchisor and a franchisee. So many businesses out there are franchised, everything from window cleaning to fast food. And typically the agreements between a franchisor, the main corporate entity, and the franchisee prohibit any kind of competition, prohibit the franchisee from, let's say you have a window cleaning business, you can't take another franchise in sort of the home repair or home maintenance world. So you could have a sandwich shop franchise if you want, but you wouldn't be able to do something in the cleaning industry. So you have the franchisee exception. Then there is also an exception for the sale of a business. Now, this is very common. You sell a business, the buyer doesn't want the seller to then turn around and take the money that the buyer just paid for the business to set up a new competing business anywhere nearby. The problem with the FTC's regulation is that it only applies to owners of 25% or more of a business. And that's kind of an arbitrary number. It seems a little odd. There are minority stakeholders in businesses that often have extraordinary value, outsized to their the share of the business that they own. So those are the two exceptions. The other thing that, and I mentioned this at the top of the video, there are things that the FTC considers de facto non-competes. So they do have a test that's put into the regulation so that if it looks like a duck, walks like a duck, quacks like a duck, it's a duck. So if it looks like or operates like a non-compete agreement, then it's going to be treated as a non-compete agreement. And what they're really targeting here is these agreements that are out there that look like a non-disclosure agreement, but are drafted in such a way as that the individual worker cannot go to anywhere else or set up a competing business using any of the knowledge that they have. Now, there are trade secrets legislation out there, but a trade secret has a very specific definition. And so the Federal Trade Commission doesn't want to see non-disclosure agreements that operate like a non-compete. Maybe the industry is very small. A case that they point out is the glass container manufacturing business. And, there's only a few companies that make, the glass containers that we use for things like beer bottles or spaghetti jars or things of that nature. So there's not very many of them. They require an enormous amount of training to train employees on how to use the machinery. And there's very few companies out there that do it. So they may have created a non-disclosure agreement that says you can't take the information that you learned here and then go use that information to work for somebody else. That operates as a non-compete, a de facto non-compete. And the Federal Trade Commission says, nope, you can't do that. Okay. So the other de facto non-compete agreement might look like something like a non-solicitation agreement. So a non-solicitation agreement will typically say to a departing employee, you can go out, you can conduct your business how you want, but you cannot solicit any of our customers. Now that's a legitimate business concern. But if you draft your non-solicitation agreement in such a way as to also encompass a broad swath of prospective customers, meaning anybody that we might do business with in the near future, that would look like a de facto non-compete agreement, and that too would be banned under this rule. So the rule itself is designed to get rid of all non-compete agreements, even if you call it something else, but still operates as a non-compete agreement. So there are some problems with this. So, before I get into the problems, let's talk about this is a proposed rule only right now. They are going to be opening up a 60-day comment period when the proposed regulation is published. And it'll probably be published within the week or so. And it'll be published, and then the 60-day comment period will take place. And the Trade Commission has asked for comments on a wide variety of things. So under the Administrative Procedures Act, which we don't have to get into, the Federal Trade Commission is supposed to collect these comments and respond to the comments and either maintain the rule as it is, modify it, or scrap it altogether. I can tell you right now, they're not going to scrap it. I do think they're going to modify it because there's a number of very difficult questions here. First is that I think the sale of the business exception is arbitrary. The 25% ownership is arbitrary. I think that will go away. The reason why I think the business sale exception will be any business sale, any sort of concept of that, is because typically in a business sale, everybody is represented by counsel. You have the ability to negotiate the terms of your non-compete. Oftentimes, the seller of the business will be engaged for a certain period of time to help with the transition. And those are negotiated contracts. And I think that it's unreasonable to have a 25% ownership threshold. So I think the Federal Trade Commission should probably get rid of that requirement. The other problem that you get into is when you're dealing with independent contractors. Now, independent contractors that you hire, these are, in theory, separate businesses. They should have the ability to negotiate the terms of their engagement. And it's not unreasonable for a business that hires an independent contractor to say, we don't want you to compete with us in this sphere. I've never really seen a non-compete agreement for an independent contractor extend more than 90 days. I've seen most of them are in the 60 to 90 day range, at least amongst the ones that I have seen. I also think it's legitimate to have a hard non-solicit saying, hey, Mr. Independent Contractor or Miss Independent Contractor, we hired you to do a job for us. We don't want you to turn around and then solicit our client to do work for them. So we brought you in, say you're a marketing agency, you hire a videographer to come in. We don't want you to circumvent us to go to the client that we hired you to do work for. So I think that there may be some modification in that realm as well. The other really hard part is I don't particularly have a problem, well, I don't have a problem at all, saying that an hourly wage earner should not be on a non-compete agreement. In fact, several states outright ban non-compete agreements for anybody who is paid on an hourly basis. The problem with choosing an hourly versus salary basis is that you may end up with some misclassification of employees, classifying somebody as say, for example, an administrative employee under the Fair Labor Standards Act. You pay them a salary, but they're not really an administrative employee. But because they're salaried, you can put them on a non-compete. I think the most likely scenario that we're going to see is some specific carve-outs. One likely is going to be somebody who is paid a salary over a given threshold, maybe $100,000 or $120,000. Another might be, what is the role of the employee? Is this a senior executive? Okay, with the ability to transfer specific executive level skills, maybe with specific knowledge. So I think you might see an executive thing. I think you may also get to see what is the nature of this person's job and role. So I go back to my medical clients. Many of them, like I said before, have non-competes with their medical providers. So the doctors, the physician's assistants, nurse practitioners, sometimes even the nurses themselves. And those individuals tend to be well compensated, but their skills are easily transferable to another business. And you will want, people who own medical clinics are going to want to say, ooh, by the way, no, we don't want you setting up a business, 2 miles away and soliciting our patients to go work for you. So I think you may see something like that that will have some sort of rule that says, okay, this is a person who has the ability to negotiate the terms of their employment a lot better than a typical hourly worker. So I think those are some of the likely modifications that we're going to see. We are going to see a rule that will ban most non-compete agreements, if not 95% of non-compete agreements. I think we're likely to see it in the next year. And I think that as an employer, you need to think long and hard about whether or not you want to maintain your non-compete agreements. If you have an employment contract with individuals, or you have a non-compete agreement with individuals, now is the time to start looking at that and seeing whether or not it's actually, one, reasonable, two, is it something that you're likely to enforce or not, and three, can you renegotiate it into a more of a sort of a traditional non-solicit agreement? For example, a non-solicit agreement, you may have a provision that says if an employee, if a client or a customer of our business goes to your business, the departing employee, within 60 days, we're going to presume that a solicitation took place. And the burden of proof that a solicitation didn't take place is going to have to be on the former employee. Whether or not that's enforceable, whether or not you can do something along those lines, is something of an open question. But you're dealing a little bit with an honor system here, to be honest with you. And I think that employers are going to have to start looking at alternative means to manage and maintain their employees in good standing, keep them engaged, keep them on staff. And hopefully you do that through either some creative compensation packages. Maybe you have to do some increased wages. Maybe you need to look at other things that keep people happy. So non-compete agreements are pretty much on the chopping block, ladies and gentlemen. It's not likely to be something that we're going to be seeing regularly. It's certainly, if they continue to exist, it's going to be in very specific areas. And it's going to be with some really hard boundaries upon their use. So if you are a business that has used non-competes in the past, or you're currently using non-competes, give us a call. We'll take a look at what you've got going on, and we'll figure out if we can find a better way for you to protect your business and your business interests. All right, so that is it on the Federal Trade Commission proposed rule banning non-compete agreements. We will, of course, be keeping an eye on the developments here. And in the meantime, if you have anything that you need to do from an employment law standpoint, please give us a call. You can, of course, contact us at mattthelawyer.com. And I will put a link down below to where you can schedule a consult so that you can come in and take a peek-see and have a conversation with us about what's going on in your world. In the meantime, go out and watch some live soccer. We'll talk to you later. Bye-bye.